Hi, everyone. Welcome back to Immigration Litigation Bootcamp. Today we're doing something a little different. So this is separate and apart from our introduction series. But Brian and I have had some big wins recently, and we thought it would be cool to come together and kind of dissect them a little bit. So, Brian, let's start with you. You had a big win relating to Kazarian, EB1 petitions. What exactly is Kazarian?
So yeah, Kazarian it's a law case. It's a decision from the Ninth Circuit Court of Appeals, and it's also a policy that is used in the EB1A I-140 petition adjudication process. Essentially, it's a second step in the EB1A adjudications where USCIS looks at the totality of the circumstances, the total evidence to decide whether the petitioner applicant, if they meet the high standards that Congress set for getting the top level genius visa green card. So it's a policy that's been in place since 2010. I think it unfairly restricts the EB1 category. And a judge in Nebraska for the first time has ruled that the Kazarian policy was adopted illegally under the Administrative Procedure Act.
Fantastic. So this is for extraordinary worker I-140 petitions. So just break it down. What's the first step of the Kazarian analysis, the evidentiary criteria that people have to meet?
So yeah, whenever Congress passed the law back in 1990, then the Immigration Naturalization Service passed a regulation, and it was a one-step a process. There were 10 criteria. You could be found. You need to satisfy 3 out of 10 criteria, and those criteria include things like having a really high salary, making original contributions to your field, judging the work of your peers in a professional setting or at conferences. It could be publishing scholarly articles. It could be having major news media coverage of you. Lots of different ways to qualify. And in that one step process, USCIS was also looking to see if you had achieved sustained acclaim, had you made extraordinary contributions. That was all a one step process. They were looking for a sustained acclaim as part of your news coverage, of your contributions, of your judging. It was all one big analysis.
Hmm.
And in 1995, the INS thought, well, we really need to break this into 2 steps. They published a proposed rule to do that, but they never went through with it. I don't think they got comments, what happened, but for whatever reason, INS backed away and said, we're going to stay with a one-step process.
Mhm.
That's the way it remained until 2010. So for 19 years, INS and USCIS, the successor, they adjudicated EB1 cases. You met the criteria. If you had that sustained acclaim, if that was part of the evidence, you got your green card. December 2010, USCIS notices that this Kazarian case came out. Mr. Kazarian had lost his EB1 petition. He filed a lawsuit in California saying they didn't adjudicate my case fairly. The trial court judge said, nope, it was fair. Mr. Kazarian appealed to the Ninth Circuit. The Ninth Circuit kind of went off the reservation. They said, we agree with the outcome at the trial court level, but we disagree about how they reached it. We think there really should be a second step, and that what Congress really meant to do was to have a step 1 with 10 criteria, a step 2 where they made this total analysis, and we think that's fair. It was total, we call it dicta as lawyers. It had nothing to do with what happened at the trial court level. They were just inventing something on the appeal level that didn't exist. And USCIS loved it. They said, this is great. This is what we've always wanted to do back to 1995. So we're going to adopt an internal policy announced by memorandum only. And we're going to adopt this, and we're going to start doing 2-step decisions for all EB1 cases. They didn't go through notice and comment. They didn't publish a proposed rule in the Federal Register. They didn't take any public information or comments on how this was going to affect people. And if this was a legislative change, if this changed people's rights under the law, that's illegal. If it's just a procedural change of how they're doing things but doesn't affect people's rights, it's okay. I filed this lawsuit and had judges in Nebraska and Philadelphia say it was not a legislative change. It did not affect people's fundamental rights to get EB1 cases. But now in Nebraska, in the Anahita Mukherjee versus Lauren Miller case, Judge Battalion said, nope, this was a legislative change. USCIS knew about that in INS knew about it in 1995. USCIS inherited that knowledge. They knew they were supposed to make this a federal rulemaking procedure. They didn't do it. It's illegal. It's been illegal since 2010.
Hmm. And so this case comes from the District of Nebraska, which is nice because the Nebraska Service Center is there, right? And presumably a lot of these petitions get adjudicated there, right?
But probably maybe half of them in the country. And it's important to note that the District Court for Nebraska is not a liberal court. The Eighth Circuit is not a liberal jurisdiction. And you're right. If half the cases in the country, it's not a binding decision.
Hmm.
USCIS has not appealed yet. But if they appeal and lose at the Eighth Circuit, then Texas Service Center is the only place currently that could use the Kazarian policy.
Wow. And so the difference between the evidentiary criteria and the second step is the evidentiary criteria are kind of objective, right? You know when you met them, right? You know if you have news articles about you. Whereas this free-floating second step, are you good enough in some vague sense? You don't really know when you see it. There's no objective criteria, right? And so to me, that was part of the problem with Kazarian is adopting a legal standard that didn't really have any actual standards to it, right? And so even if you theoretically, even if you met all 10 criteria, they could still say, oh, you're not at the very top of your field, right?
I've never met. I've heard of people with 8 or 7 criteria that have got denials under step 2. And I'm going to have a lawsuit filed probably this weekend for one of them. I mean, to have 7 criteria is amazing. Even getting 3 or 4 can be very difficult, even if you're a professor at a major university. And USCIS loves to say, well, postdoctorates are early in their career. What if you just created, the cure for cancer as a postdoc? Doesn't mean it wasn't extraordinary or an extraordinary contribution. Or they'll say, well, you're not the greatest neurosurgeon in the world. Well, if you're top 3% or 5%, you are EB1A. So it definitely has been a problem for the courts. They're much more comfortable, judges, in saying that USCIS has mislabeled or opposed proper evidence in step 1. Step 1, as you said, is objective, and they're using the matter of Chihuahua preponderance of the evidence standard. If you have a 51% likely chance that you satisfied criteria 3, you're supposed to get it. So they have definitely been more aggressive in denying cases. And when I've won step 1 at summary judgment with judges in Michigan and in Wisconsin, USCIS a couple of years ago switched their strategy. They became much more open to adopting or conceding 3 or 4 criteria and then denying under step 2. Mm-hmm. They know it's harder for the judges to weigh out the evidence and see if step 2 has been applied properly. Mm-hmm. So my strategy now going forward, I'm attacking only the legality of step 2. Anyone that has a step 2 denial, please email me, Brian Green at greenusimmigration.com, or look me up on Google. My email's on my website. I'm just going to attack step 2. And Judge Battalion said that USCIS had to approve the I-140 because Ms. Mukherjee satisfied 5 criteria and was clearly qualified under step 1. Not every judge is going to agree and do that much, but I think Judge Battalion's analysis is really straightforward. And I think it's going to be much easier for judges around the country to now say under step 2 is illegal. It's been illegal since 2010. Under the corner post decision from Supreme Court, people from 2010 can sue. People from 2020 on certainly can sue under the 6-year statute of limitations. I think a lot more judges are going to be comfortable now saying under Loper Bright, we are not deferring to the agency. This is an illegal standard. And they don't have to get into the minutia of the evidence on step 1. They don't have to get into the weighing of the evidence under step 2. They can simply say black and white, step 2 is illegal. Every denial under step 2 is ultra vires and has to be reopened and properly adjudicated under the pre-Kazarian standard, which brings me to the weird situation. As long as USCIS keeps Kazarian in place, people that sue get pre-Kazarian adjudication. People that don't sue get Kazarian adjudication.
Interesting. So I think this decision has been talked about a lot. I know a lot of people have gotten denials at this step 2, and you've probably heard from a lot of people since then wanting to know, you can get my petition
About five
approved,
or six
right?
hundred, yeah.
Okay.
It may be affecting a group of people as big as 60 or 70,000 people if you go back 17 years.
And this is a district level decision, and district level decisions are never precedential, right? So it's not binding on anyone. What do you see as the path forward for litigants, people who want to challenge this, whether it's in Nebraska from the Nebraska Service Center or other service centers? What does it look like?
I'm encouraging people to sue in Nebraska first because Judge Battalion has been a judge there for a long time. He's a senior status judge, very respected. So it's not a mandatory decision. It's not mandatory authority. But I think in Nebraska and in the Eighth Circuit, it's going to have good persuasive authority. So anyone that has a Nebraska decision, I'm saying just file in Nebraska.
Hmm.
Anyone that has a Texas decision, I'm saying, well, let's look at where you live. And if you don't live in if you live in Texas, if you live in the Fifth Circuit, Ninth Circuit, I'm encouraging those people to file their lawsuits in Maryland because this is not a argument. This is not a lawsuit saying that the officer got step 2 analysis wrong. My lawsuits are that the step 2 analysis is illegal as a national policy decision. So those cases can be brought in the District of Maryland. The USCIS moved their headquarters from DC. A lot of immigration lawyers never realized that, but they've been in the Maryland suburbs since December 2020. So, more than 5 years now. And I think the judges in Maryland are going to let these cases be decided in Maryland at the policy level. So my first preference is Nebraska. My second preference is Maryland. After that, I'll be filing a lawsuit this weekend, probably in Michigan, maybe one in South Carolina, maybe another one in New York. I've got a number that are going to Nebraska, a number that are going to Maryland, and anywhere outside the Ninth Circuit, Fifth Circuit's good. Once I get enough decisions that there's momentum toward a consensus at the trial court level, maybe that's 5 or 10, 12 decisions, then I'm going to probably bring some good test cases in California. I can't stop other people from litigating in California. So someone may beat me to the Ninth Circuit, but I think eventually we're going to either lose at the Ninth Circuit or at the district court level. The judge would say, I agree with you, but Kazarian is still good law in the circuit. My hands are tied. You have to appeal. And at that point, the petitioner is going to appeal, and we're going to ask the Ninth Circuit. And I'm sure that people like AILA or organizations like AILA, NAFSA, a lot of organizations will probably do amicus briefs saying that Kazarian has been wrong for a long time, that this is improper. Once Kazarian is overturned to the Ninth Circuit, then we go to the Fifth Circuit trial courts, file the lawsuits there, and say that the Amin precedent in the Fifth Circuit that's based on Kazarian is no longer viable because Kazarian has been overturned. So I think you sue everywhere outside the Fifth and Ninth Circuit. And there's an appeal at the 11th Circuit. Mark Prada is briefing that right now. The 11th Circuit might be the first circuit to say that Kazarian is illegal. He's using the Mukherjee case in his appeal brief. And once we get the Ninth Circuit to overturn it, we go to Fifth Circuit to overturn it. If the Fifth Circuit wants to be an outlier and just keep their decision and be the only circuit that says Kazarian's okay, then USCIS has to decide, do they want to have two different sets of adjudication policies going in at the same time in the same country? I think that's not sustainable.
One thing I love about this is that you really targeted this issue for quite a while, did you not? I mean, you basically told the whole
probably got 3 years now.
Yeah, you told the whole world, I want these Kazarian cases. It seemed like an uphill battle because, as you said, there's been some losses, but you kept at it and you finally won. And I think it's a great example of how to target issues proactively. I know, like, really good appellate litigators will practice like this. Like Ben Winograd will target an issue, figure out the issue, tell the community that he wants to fight it, and then he gets the cases. And so I think it's an awesome example.
Once you've done the hard work, I mean, I have to give Mark Prada a lot of credit, and also Amy Maldonado and Ksenia. What's Ksenia's last name?
Mayorova?
Yes. Those three together have done a lot of the work over the years on the EB1 litigation. And when I got to the point where I was doing my summary judgment briefing in Nebraska, Philadelphia, I've got a case fully briefed at the Eastern District of New York in Brooklyn. And I think the judge there, who was a magistrate judge for like 15 years, Now he's a full district court judge. He was a former, he might have been the civil chief in EDNY back in the 90s. He was very interested in the argument I gave about a year ago in Brooklyn. So we might have an EDNY case soon. I'm going to have I lost in Philadelphia. I'm going to ask the judge there to reconsider. And I'm
Mm,
going to ask a judge in Nebraska that ruled against me to reconsider. I think the key is if it's a legislative change, then it clearly is an APA violation. So I think we're going to see more district court decisions coming soon. But my work was based on Mark Prada's work, Ksenia's work, and Amy's work. They open source gave me their work. I put it into my briefs, and now Mark Prada's got it back from the decision from the judge in Nebraska. He's putting it into his appellate briefs at the 11th Circuit. We are working collaboratively as the immigration bar. We should. And I'm just the first person to get the decision and the win. Other people have tried to go directly at Kazarian in the Ninth Circuit and use this argument, and the judges are like, no, Kazarian's good law. I
mm.
think you really need to go outside of Fifth and Ninth, win a number of cases, and then you're giving the judges at the trial court level and the circuit court level the citations they need to show that it should be overturned.
Mm. So fundamentally, you won on notice and comment. The government didn't follow the required procedures. And this is happening more and more. I mean, the government loves to skip the normal procedures. And if it's okay, that brings us on to my case, unless you had any more to say
Yeah, I
about
would just say that
Mukherjee.
Loper Bright says the Supreme Court decision from what was it, June 2024, it says that the question of whether something is a legislative change or not is not a decision for the agency, whether
Mm,
it's USCIS, State Department, EPA. The courts are independent judges of whether or not rule and comment is required. So
mm.
we're no longer trusting the agency to say, no, no, don't worry. We're not going to change anyone's rights under the EB1A law. The judges are now the gatekeepers. So I think this is probably the most powerful Loper Bright decision in immigration law so far in the last year and a half, is saying that, hey, USCIS policies that predate Loper Bright, they don't survive Loper Bright review now.
That's great. So my case, I also won on notice and comment among three grounds. One of them was notice and comment. And so this is a case involving the State Department. Over the past few months, actually over the past year, the president has started to ban the immigration of widening categories of people from a growing number of countries. And it culminated in January, mid-January of this year, when the State Department issued a full immigrant visa ban on everyone from 75 countries. So we're talking almost half the world. Now, some of these countries were subject to previous what we call 212F proclamations, findings by the president that they shouldn't be allowed to immigrate. But a lot of these countries had no 212F proclamation. So the State Department was kind of acting alone in banning their visas. And this policy came out of left field, not much warning. And I won an injunction against the policy. As far as I know, it's still the only injunction that's been entered, and it's the first court decision as to this policy. But the case is Sangster versus Rubio in the District of Nevada. I was representing this family on a pre-existing visa delay case, and so I already had a case going. When the policy came out, I amended my complaint and filed a motion for a temporary restraining order. And the judge found that the policy was likely unlawful, and she entered the TRO. She ordered the government not to apply the policy to my clients. The first basis for her ruling was that the policy conflicted with the public charge ground of inadmissibility. So the policy was supposedly based on a fear that anyone from these 75 countries is going to become a public charge. And so they cited 212A4 as the basis for the visa ban. If you actually read 212A4, what it says is the consular officers are supposed to consider various factors. They're supposed to consider, the applicant's financial condition, their education, all these things. But the policy basically prevented the officers from doing that because it said, even if, regardless of their individual factors, you have to ban them. right? You have to deny them. So at a very basic level, this policy was not a faithful implementation of the statute. The statute wanted consular officers to adjudicate cases individually, case by case, not just impose some blanket rule on everyone. So that was the first ground. The second ground was that it was in excess of statutory authority. So 221G instructs the consular officer to deny a visa if the person is not eligible in their opinion. What the policy did was it told the officers after you've done the blanket ban, then you're supposed to keep taking new evidence. However, even if you find that they're not a public charge, that they're not inadmissible, you still have to deny a visa under 221G. So the statute says 221G, deny the visa if you think they're ineligible, but the policy said deny the visa even if you think they are eligible. So there's a very basic conflict between the policy and the statute. And then lastly, as I said, we won on notice and comment. So this was a legislative rule applying a Ninth Circuit standard here. Basically, without the policy, these consular officers who were supposedly supposed to deny the visas, without the policy, they wouldn't have had a basis to deny the visa. And so therefore, this was a legislative rule and has to go through notice and comment. So
Yeah, I think it's important. I think both these cases show the government likes to do things fast and dirty, and they want to skip the rulemaking because rulemaking might take what 3, 4, 6 months. There's public comment, and then there's going to be a lawsuit because people will say, "Well, you're not really taking the comments into effect, or this is narrowing the statute, and you can't do that." They want to go ahead and have these policies take effect immediately. And then we're in the, like you're saying, we're in the TRO or the preliminary injunction world where we're trying to get things retroactively stopped. I think these decisions, yours is State Department, mine's USCIS, I think this shows the post, what was the name of the case that was overturned by Loper Bright?
Chevron.
Yeah, this is the post Chevron world. I've already forgotten about Chevron. That's how far in the past it is now. But for 30 or 40 years, I think 1985 until a year and a half ago, federal judges in large part defer to agencies. And Chief Justice Roberts said that's not the role. The constitutional. Let's go back to 1787. The role of the three co-equal branches is to check one another with checks and balances. And in the Loper Bright world now, you and I and these, whether you're at a law firm like Clark Hill and you have lawyers all over the country, or if you're a solo lawyer like me in Denver, we have the power to stop a federal program in its tracks because it's illegal. And that power shift has happened.
Mm-hmm.
And it may, if we win enough times, it may make some agencies do notice and comment and follow the rules because it's probably easier for them to do it than to fight the litigation and all the costs and the time involved in that. So I think our decisions in the last 2 weeks really have shown, and I hope we talk about this at the American Immigration Lawyer Association conference in San Diego in June, how powerful these tools really are now.
Yeah, definitely. So we have really made the best of this Loper Bright world that we're living in. Let's see, I think in your case, you didn't have, there wasn't really any question of jurisdictional bars or anything, right? An I-140 is non-discretionary, and you clearly had a final agency action that you could sue on. So it wasn't.
There was no motion to dismiss.
Right,
There was no Rule 12 motions. I haven't had USCIS ever challenge. In the EB2 NIW world, absolutely, you will see motions to dismiss saying that the jurisdiction stripping for discretionary decisions is involved here. Whether or not that's really the reading of the 1996 law, whether these things deal with removal or not, I don't think they do. But certainly EB1, I-140, O1, H1B, L, all of those cases, there is jurisdiction for judges to review the decisions on the merits.
Absolutely. In most cases, there's some jurisdictional bar that you have to tangle with. In my case, I had to deal with consular non-reviewability, which says that the courts basically won't entertain a challenge to an individual visa denial. And now it's a pretty formidable doctrine. It's strong. You cannot sue to reverse a visa denial, right? People who have tried and made little inroads ultimately don't get anywhere. They get shut down by the Supreme Court, right?
But you can challenge policies.
You can challenge policies,
I just had an
right?
E2 denial in Argentina at the U.S. Embassy in Buenos Aires. The consular officer had created extra requirements that don't exist in the regulation or the statute. He had a worksheet that he was checking off, and the worksheet showed ultra various requirements. So we filed a lawsuit in Miami and said, we are not challenging the decision, we're challenging the policy. And they resolved it and got that visa issued within about 2 or 3 weeks.
That's
So if you
fantastic.
challenge policies in the US, you may not run into the consular non-reviewability problem, or at least you're going to have a better argument to survive a motion to dismiss, because you're not saying we don't care what the consular officer did. And in your case, same thing. We're challenging the policy level of decision.
Right. And what I found is that if you're challenging a policy, it's actually best to do it in a forward-looking manner for a visa adjudication that's going to come up, because that way your client has standing, and a court order is going to redress the harm that might occur. Whereas I read a lot of cases where people had already been denied a visa. Now, in order to have standing and redressability, they needed a visa application that was still viable, right? So if you have no chance of ever getting a visa in the future, then you might not have standing to challenge the
Now,
policy, right?
if you have a 221G denial, you can argue it's still a viable case. If it's a
Yeah,
214B denial, it's pretty hard to argue that, right? You can still
yeah,
apply for a new visa. And if you're not permanently banned for some reason, I think you might still have standing.
right, right. I guess my point is that some of these visa applications can take quite a long time to set up, right? Let's say you have to do a petition first and then go through the whole consulate. That can take years. So you want to be proactive. If there's a policy that's illegal and that's going to impact your case, go after it, before there's a visa decision.
Choose your plaintiffs wisely.
Yeah. And it was nice to do this case in the Ninth Circuit. I know Ninth Circuit was bad on Kazarian, but the case law was favorable, and there's favorable DC Circuit law about challenging State Department policy. So I would say at this point there's a consensus that visa policies are fair game, even if individual visa challenges are not. So big week, big couple weeks for us. We just wanted to share these and hopefully show, two kind of different paths to making an impact and making inroads into policies that the government is using that are edgy or unfounded or stretch the statutes a little bit. Anything else, Brian?
Now, just keep fighting. There's a lot of work out there to be done.
There are a lot of policies that are unsupported, so keep going at it.